Very good morning, students. Today we are going to see basic information about intellectual property rights. Before entering into the topic, what we are going to see in this topic in the sense, what do you mean by intellectual property? What is the definition of intellectual property? What is the history of intellectual property, when it is started? What is the major concept of intellectual property? Why it is required? All the information we are going to see in this slides. First, we'll enter into the topic like what do you mean by intellectual property? Intellectual property rights refers to legal rights given to the inventor or creator to protect his invention or creation for a certain period of time. Particular period of time, we want to protect our inventions or we have some creativity activities, how we are making it to protect from others. That's the first meaning. Second, we are going to see the legal rights confer an exclusive right to the inventor or creator or his assignee to fully utilize his invention and creation for a given period of time. The particular period of time, the inventor and the assignee, they will be using the particular property by his own. The other people should not use that particular thing without his permission. That is what the intellectual property rights have started. What is the major definition? Let me explain. Intellectual property is the product of the human intellect, including what are the things is included in the sense creativity concept, a new concept, different concept he is creating, and new inventions, new inventing things. Okay, then industrial model. Sometimes what are the design of the industry, all these things. Trademarks. Trademark, the company have some extraordinary simple, that is going to be a trademark. And songs, literatures, some writing works, symbols, some designs, names and brands, etc. So intellectual property is the product of the human intellect, including the creativity concept, inventions, industrial model, trademark, songs, literature, symbols, names, brands, etc. Another definition is going to be talking about actually intellectual property is right do not differ from the other property rights. What are the other property rights which we are having? The same thing will be followed in the intellectual property rights also. They allow their owners to completely get benefit from his work. Whatever he is inventing, whatever he is creating, the full benefit has to be reached to the particular person, those who are inventive or those who are assignee of the particular product, which was initially an idea that developed on crystallized. That is very important. And what is another the definition is going to talking about? They are also entitled him or his, that is inventor or inventor creator, to prevent others from using. Some of the people should not use his without his permission, and dealing or tampering with product without the prior permission from the inventor or a creator. Either he or she can in fact legally sue them and force them to stop and compensate for any damages. If somebody using our own the particular inventor product or trademark or invention, whatever it may be, without his prior information, they should not use. First thing. If so, they are using in the sense we can file against a case on them and we can ask them to stop and we can get a compensation how much damages we got from that. So this is the major definitions we are going to understand. The next topic, what is the major history of the intellectual property right, when it is started? That is what we are going to see. The first introduction itself, I would like to say, intellectual property rights is not a new concept, because everybody innovative or creating something, they want to protect their intellectual by the way of by the using the way of legal or law. Okay, It is believed that intellectual property right initially started in North Italy during the Resonance area. What is that Resonance area? In the sense, in 14th to 17th century, the people are very emerged to create a new things and inventing the new things. So that period is called rebirth period. That Renaissance means rebirth. Okay, in Italy it was happened. And 1474, Venice issued a law regulating the patent production that granted an exclusive right for the owner. In 1474, Venice only released the patent right regulation. The patent, in the sense, the people they are having their own, and they, the owner have a full right to use the particular model. Okay, the copyright dates back to 1440 when Jones and Gutenberg invented the printing press with replaceable movable wooden or metal letters. Printing press, they have a letters, they will first, before that it was used in the format of all in wooden, but recently they want to change this with the help of steel or metal. So that one they only introduced. So they had a copyright of the particular product. They only introduced. This is the major history of when it is started like that. It is in such a way only intellectual property has started. And late 19th century, a number of countries felt that necessary of laying down laws regulating intellectual property right, because so many people are started emerging, they are creating a new things. So that owner, they particular the people want to protect that act. Regarding that, they started. Globally, two convention constitution bases for intellectual property system worldwide have been found. First one is Paris Convention, and the second one is Berne Convention. Paris Convention, when it was started for the production of industrial property in 1883. The Berne Convention for the production of literary and artistic work, it was started in 1886. Okay. Protection of intellectual property right. What are the protection we will have? Protection of intellectual property rights allows the innovator and brand owner, patent holder, copyright holder to benefit from his work, labor and investment, which does not mean monopoly of intellect. That is a major reason. And such rights are set out in the International Declaration of Human Rights, which provides for the right to benefit from the production of moral and physical interest resulting from the right holder's work, literal or artistic product, isn't it? So next, what is the difference between forgery and the counterfeit? So when we are seeing all this intellectual property, sometimes we are going for case and all in the sense, some people will do the forgery or they will be doing the counterfeiting. What do you mean by forgery? Forgery of a trademark means a complete transfer being identical, the same thing they will use from the unique brand, or transferring the main part of their making forged brand greatly identical to the original one. Okay, same ditto they will be producing. Okay, forgery is the fraudulent act actually of creating a copy of a document or signature or bank note or work of authorships that is intended to be passed off as genuine when it is not. Okay, that is what forgery. What do you mean by counterfeiting? A trademark, counterfeiting a trademark means making a brand similar in total to the original one in a manner that might mislead the public to connection with the source of the goods that are marked by the brand in question. Same ditto they will be producing all the things. Okay, there is no changes, difference, nothing will be there in the counterfeiting, and it will damage the original brand like marked by the brand in a question, that one making. So this is the major thing we would like to see. So these intellectual property rights, we are having for like trademark, design, trade secret, all these things. They will maybe do a forgery or counterfeiting they will do. So first we have to clearly understand what do you mean by forgery and counterfeiting. automatically how the intellectual property can be protected from the forgery people and the counterfeiting people, we can understand. Okay, next class we will see elaborately what are the things is going to be intellectual property. Thank you.